Good morning, everyone. Thank you so much for joining us on this gloomy day. We are here for part two, and it is an absolute honor for me to introduce Miss Heather Nadler to you. Heather, please take it away.
Thanks so much, Jade. Appreciate y'all inviting me to give this presentation. We really like giving this presentation because I do feel like, in particular, attorneys' fees can add up, and the guardianship is absolutely something that most folks can do on their own. And if we're going to be looking at where to put attorneys' fees, I would say, do the guardianship on your own, and let's not print a special needs trust off the internet. Glad that you are here and getting this information. I'm going to assume that most folks watching are caring for a teen who is about to be an adult. Poof, by virtue of the fact that they turn 18. The law says you are an adult when you turn 18 until someone says that you are, even as an adult, not able to make your own medical and or financial decisions. And so that's what guardianship does. So that's what we're going to hear about today, how to approach the court, because it's the court who makes that determination. So with the, here's me. I think, I've been a familiar face around Focus for a long time. Hopefully y'all are familiar with me and our firm. We practice elder and special needs law, about 80% special needs law these days. So we do a lot of this stuff all day, every day, and are happy to be able to share this information with you. Despite the fact that I'm a lawyer, I have to tell you, this is not legal advice. It might sound like it. It's just presented for informational purposes only and is not a substitute. Your mileage may vary, basically. So I think we hear the term guardian thrown around a lot, guardianship, and a lot of folks think they know what that means, but there are some intricacies that are associated with it that I just wanted to point out here in this first slide. So when you approach the court and say, okay, my child needs a guardian, that is someone who is in charge of making health and safety decisions. There might also be a need for a conservator, and that conservator is the person who is responsible for making financial decisions. Before, I want to say it was 2007, I think, might have been 2010, we used to refer to this as guardian of the person and guardian of the property when I was first practicing. And I think that was a lot more English speaking than this term conservatorship. But if you think of it as a guardian of the property, that's what a conservator is. And then a guardian is a guardian of the person. So one of the things that's important to realize with guardianship is this is not just showing up at the court, filling out some paperwork, and poof, you are a guardian. In actuality, there are a lot of players that are involved here. So this slide goes over who those players are. First, we have the petitioner. That is the person who is approaching the court and saying, okay, this person needs a guardian, and here is why this person. So that's the person, the petitioner puts together the petition and files it with the court. And actually, as we'll hear in a minute, there may be two petitioners. Usually there are. We'll talk more about that in a minute. Then we have the proposed ward. The proposed ward is your child. That is the person who we are saying needs the assistance and the oversight of another in making these types of decisions in their daily life. So proposed ward becomes, when the guardianship is granted, the ward. And that term ward, I feel like, is a lot of a misnomer. People think that if there's a ward, they're a ward of the state. And that can be the case. But in this instance, when we're talking about guardianship for an incapacitated adult, the person becomes the ward of the guardian. So right now, if you become your child's guardian, they are a ward, but they are your ward, not the state's ward. So in the petition, number 3 here, we also put together who it is we want the guardian to be. Now, usually that is the petitioner. The person who's filing the petition says, hey, this person needs a guardian and I want it to be me, but it doesn't have to be. So sometimes those vary, but typically, and I would imagine in most circumstances, for focused families, it is going to be the petitioner who is also going to be the proposed guardian. There is going to be an attorney appointed for the proposed ward. When we go through guardianship, we are taking away rights, as we will see again in a later slide. we are taking away rights. And for that reason, the person who is potentially going to have their rights taken away has the right to legal representation. And so therefore, when the petition gets filed, the court is going to appoint an attorney to represent the proposed ward. A lot of parents will ask me, well, can we hire the attorney that will represent our ward? No. And so it must be the court appointed attorney, unless that person, your child, could reach out on their own and hire an attorney. Probably not going to happen, but it can't be a process that's facilitated by you. Number 5 is the guardian ad litem. The guardian ad litem is someone who gets appointed. It's a lawyer, typically in most counties, that gets appointed not to represent anybody, not representing you as the petitioner, not representing the proposed ward. The guardian ad litem just takes a look at the situation as a whole and says, yeah, judge, it looks like everything's in order. You know, I've talked to everybody and things just seem to be above board here. You don't always have a guardian ad litem. In fact, you usually don't have a guardian ad litem. But if you are asking for something out of the ordinary in the petition, and I'll give you some examples later on when we actually look at the petition of what that might be, there could be this guardian ad litem appointed. Then, of course, we have the judge and the clerk. Those are both the components of the court. You will deal a lot with the clerks before you ever get in front of the judge, and your dealings with the judge are going to be limited to the hearing, you know, when you're standing in the courtroom or when you're sitting on Zoom face to face with the judge. But other than that, it's the clerks that you'll be dealing with. There is also an independent examiner who is appointed. You will see here in a minute when we look at the petition, we're going to put together a lot of facts, medical facts, about the proposed ward. And the court is not going to take our word for that. The court says, all right, that's great. I believe that you think that. But a lot of the guardianship process, as we go through it, you kind of have to think of it as not every guardian necessarily is trying to do the right thing. Some people have bad motives. And so that's why a lot of these players are put into place, and so many independent people have to be involved. The attorney that the court appoints, the examiner that the court appoints. And so that independent examiner is going to be someone who meets with the proposed ward and then reports back to the court and pretty much verifies, hopefully, what the facts were that were put into the petition. One more person who is involved here we'll see on the next slide. Oops, wrong direction. And that is the second bullet point here, and that's the sheriff, or potentially a private process server. Some courts have moved to using a private process server, or you can always request that a private process server be used. So when this petition gets put together and filed with the court reviews it, makes sure that there is sufficient evidence, that it's not just, a terrible petition that's lacking all the needed information and there's no point in wasting time going forward with it. Or if the court looks at it and says, doesn't sound to me like this person needs a guardian, the court can dismiss it before going any further. So that's why you want to make sure that your petition is beefed up with lots of good information and facts. When it gets filed with the court, the sheriff is then going to serve it on your child, and it must be personally served on the proposed ward. It can't be, oh my gosh, they're going to have no idea what you're even handing them, so just give it to me. Doesn't matter. Again, if you think back to bad motives, there needs to be, direct involvement with the ward. And so when the sheriff or the private process server shows up at the house to serve, the ward needs to be there and needs to be physically given the possession of the papers, even if they have no idea what it is that's being handed to them. So in order to get the petition started with the court, the petitioner is the one who is responsible for the fees. Now the fees are pretty expensive. It's about, probably a minimum of $700 to file the petition with the court. That's not attorney's fees. That's not anything. That's the money that you have to pay to the court. And many counties are more than that. And the reason that those fees are typically high, if you've ever had any experience with filing a legal action, usually you're more likely to see $200 range. is what's associated with those filings. But in these probate proceedings, the filing fee goes to pay the court-appointed attorney, the medical evaluator. If there's a guardian ad litem, there would be additional fees. It pays the process server. So that's why these fees are higher than what you might see in a typical filing. Now there is an opportunity to file what's known as a pauper's affidavit with the court, where you can submit paperwork to the court regarding your finances, your assets, your income, and can get a waiver or reduction in those fees. And that pauper's affidavit would be available from the court, but you have to, pass their financial scrutiny to see if you really qualify for that. So getting the petition started, any interested person can serve as our petitioner. And, typically that interested person is a family member or the friend or the person who's been serving as the guardian when the child was a minor. Typically that interested person is someone like that. But it could be, a lot of times we'll see with older adults maybe who don't have family or don't have caregivers and they're living in a facility. That facility can actually petition to get this started. So that gives you an idea. When I say anyone can be an interested person, anyone can be an interested person to initiate the petition for guardianship. So you must have two petitioners or one petitioner and a doctor's affidavit. In our office, in our practice, typically we go strictly with two petitioners. If you try to use the doctor's affidavit, though people might think, oh, well, that's going to make the petition look better. You get tied up in deadlines. The evaluation of the ward has to take place within a certain number of days before the doctor provides the affidavit, and then that affidavit has to make it to the court within a certain number of days. And it just puts you on a time frame that is unnecessarily burdensome and can be very difficult to get those documents out of the doctor's office in time. I'm sure I don't have to tell this audience about that. So what we typically will do then is we use two petitioners. It might be two parents. It might be a parent and a grandparent, a parent and an aunt and a grandparent, whoever. Just as long as they are two adults, they can get that process started. The forms for filing a guardianship, it is a standard form. Even our office, we use the standard form. You want to use the standard form. You want it to be what the court is used to seeing. And so the standard form is Georgia Standard Probate Court Form number 12. And all probate forms for Georgia probate courts, the standard forms, are available at www.gaprobate.gov. The formatting on them is very frustrating to work with, but apart from that, you just got to have patience with it, make it work. It's also fine to just print it out and handwrite it. That's fine, because believe me when I say the formatting is frustrating. But here is what the petition actually looks like. So hopefully you can pull this up and see on your screen what it is. We have got so you're of course going to fill out the probate court of where it is that you are going to file. It is the probate court where the proposed ward lives. I've actually got this on the next slide. Let me go ahead and advance to this. Okay, so now you can see kind of the filled in part. And so it's going to be the probate county where the proposed ward lives is what you're going to fill out up here on the first red part. The full name of the proposed ward, so that's going to be the name of your child. Estate number, you leave that blank. That will get assigned by the court when the petition gets filed. Here we'll see that it's petition for appointment of a guardian and or conservator, and the court uses the same form. If you are not asking for a conservator, you can go ahead and just cross that out and make it clear to the court that, hey, we're only asking for a guardian here. The reason you might ask only for guardian and not a conservator is a conservator is put in charge of making decisions regarding financial affairs. And a lot of 18-year-olds, especially 18-year-olds with special needs, where parents have been warned for years, probably don't put anything in their name or put everything in a special needs trust. If the ward doesn't have anything personally in their name, sure, they might meet the standard for having a conservator appointed, but guess what? they don't have anything. So let's not go to that trouble. Being a conservator does mean filing budgets every year and filing accountings every year for the work, that everything that went on over the past year. So if that can be avoided, we typically seek to. If we have time towards the end, I'm going to address something we've been doing in our office lately, which is kind of a suspended conservatorship, or asking the court to make a finding that there would be a need for a conservator, but just not appointing one right now. But we'll get to that in a minute. But for the time being, I think for this audience, most folks are going to want to just cross out that conservatorship part. So here we put our two petitioners. So we've got our petition of the first person who's going to file. And of course, we've got their name, their address, the basics that the court wants to know. The court also wants to know their relationship to the ward. And as far as those two addresses, they want an address and then a mailing address if different. So then the information for our second petitioner goes down here. And then you'll notice right here, this person also needs to initial. So that person will initial right there saying, yep, I'm your second petitioner. And then we provide the same sort of information. Then you'll see a note down here regarding, there's also an option for B. If you are going with the doctor's affidavit instead of a second petitioner, you would initial right there and then provide the doctor's affidavit, the name of the doctor. But again, typically not my recommendation to go that route. So here is the second page of the petition. This is kind of where we're starting to get into details about the proposed ward. So of course we need to provide the name, the age, the date of birth, the social security number. And I've made a note here that you do have to list the full social security number. I know we get concerned about giving out full social security numbers, especially in a court record document. Guardianship proceedings are sealed from the get-go. When a guardianship is initiated, no one can get access to that file except for the attorneys that are involved, the petitioner, and the ward. So that it is safe to list that social security number there. You'll provide the address and the address where the proposed ward is currently living, if that's any different. If it is different, you'll provide that information there. Also, right here, it says which is a, and a lot of people look at that and say, huh? I just lived at my house. So if it is the family home, you put that. If it's a group home, maybe they're off at college in a dorm situation, a treatment center, a hospital, whatever it is, they just want to know for the address that you've listed where they're living, what kind of facility or property is it? Then telephone number. So if the proposed ward is reachable by phone, you would list the telephone number there. If not, if maybe the proposed ward is nonverbal, doesn't have a phone, put a phone number there and then just in parentheses, put whose phone that is. But this is, the information in this paragraph is basically designed for the sheriff or the process server so that they know what they're doing. And if they want to call ahead and make arrangements to try and schedule the service of the petition, that's what this paragraph is for. Number 2 is, will the proposed ward be moved within the next 3 days? This, I would think, again, for this audience, probably the answer here is no. But if it were some sort of crisis situation where, oh my gosh, this person's in the hospital now, but don't know that they necessarily will be within the next 3 days, they want to know is if there's a likelihood they're gonna be moved, or if it's probably still gonna be found at that address you've listed in number 1. So is the proposed ward a citizen of a foreign country? If they are, then you would mark yes there, and that includes dual citizenship. And so if there are, then you would need to answer those questions there. Basically, there's a convention in place that says if the United States is putting a guardianship over a citizen of another country, you have to notify the consulate for that country. So that's why that's there. Then this is the kind of the crux of the petition here, paragraph 3. Is a guardianship necessary? because the ward is unable to make or communicate significant responsible decisions regarding their health and safety. So you're certainly going to mark yes there. Then is a conservatorship necessary because the proposed ward lacks the ability to make or communicate significant responsible decisions concerning the management of their property? And you may put yes or no here. Certainly, if your child is working and has income, if your child has bank accounts that are already in their name, then they have property. So then you would mark yes there. But apart from that, if you mark no, you can put something there to the effect of the proposed ward doesn't have any property right now, and their only income is Social Security benefits, likely SSI. If that's the case, you want to make it clear to the court that those benefits are not paid to the ward, but they are paid to the representative payee, to the parent on behalf. That's typically how things get set up. That's oftentimes when going through the application process, how people want to get things set up. So if those benefits are paid to a representative payee, the rep payee, as they are known, is responsible for reporting to the Social Security Administration. So therefore, the court says, all right, yeah, this person's getting Social Security benefits, but we recognize that, you know, the rep payee has to report to Social Security on how those are spent. So we, the court, are not going to, you know, make you double report on that. So you want to make it very clear because that keeps you out from having to get a conservatorship if you don't otherwise need one. So then, if you answer yes to A or B, provide facts that support your claim that there needs to be a guardian appointed. And then you will see they give you 1, 2, 3, 4 lines to do that. And the forms that you pull up online will be PDFs. And like I said, a pain in the neck. So what you might want to do here is just say, see attached exhibit A, and then you'll be able to attach on the back, you know, because you're going to need more than these 4 lines to explain what it is that leads you to believe that your child needs a guardian or conservator. I want you to need more than 4 lines to explain that. So we're going to come back to that. We're going to come back to all of these, but I'm going to go ahead and give an overview right here. So that's paragraph 3, which is really the heart of things. Paragraph 4 is where you nominate who is going to serve as guardian or conservator. So you would put that person's name there or those people's name there. Parents often ask, is it okay to serve as co-guardians? And the answer to that is yes, so long as the 2 parents are united on what is best for the child. Even if parents are divorced, I've had them serve as co-guardians if you can truly demonstrate to the court that the 2 of you are working together for what's in the best interest of the child. Important to realize with guardianship, it's 2 halves of a whole. It is not an either or situation. And if you show up at the emergency room with your child and you have the letters of guardianship that say there are co-guardians, the emergency room is absolutely within their right to say, well, it's great that you're here, but where's the co-guardian? I'm not saying that would happen, but I'm saying it could. And even with that caveat, I would say the vast majority of my families that I work with where it's appropriate, they do choose to be named co-guardians, but it's just important to understand that that scenario could present itself where both of you have to be present for something. Then for number 5, the foreseeable duration of the proposed ward's incapacity is permanent. You know, sometimes you might be doing this because someone has had an accident and is making a slow recovery, and maybe it's not going to be permanent. But more often than not, when we're going to the lengths of getting a guardianship in place, it's going to be permanent. And then the court goes on to ask, are there any rights that the ward should be able to maintain? And there are more slides on this. Like I said, this is just an overview. We're going to come back to it. But for example, do you want the ward to still be able to get married? Do you want the ward to be able to attend a college program? If so, there are certain powers that need to be retained. And again, more details on that to come. But that's what the court is asking here. They're saying, okay, if we do award guardianship, are there any powers that the ward should still retain for themselves? Paragraph 6 here has to do with notice. So, you know, again, thinking back to my statement earlier that not all guardians are necessarily doing the right thing or have the best of intentions. The court sets forth the hierarchy of folks who have to be notified on behalf of the ward that this proceeding is happening. That gives them the opportunity to say, oh my gosh, do not let these people be the guardian, and to come forward and notify the court if they have concerns. So we'll look more at that in a minute as well. All right, so coming back to paragraph 3. This is what we call in our office truly the heart of the petition, because this is what the court looks at when it's making that initial determination of, are we going to allow this petition to get filed, or are we going to send it back to them and say, no, we're not convinced that this proceeding should go forward. So it is not enough to say, my child has been diagnosed with autism, and move on to the next paragraph. So some people who have an autism diagnosis need a guardian, some don't. So the more important question here is, yes, certainly include the diagnoses there. But if someone were to ask you, hey, what demonstrates that your child, give me examples, give me proof, give me limitations that they have. How does their diagnosis impact their day-to-day functioning? That's more what you want to be providing in paragraph 3. So I have here on the next page some samples to let you know that I'm serious about this. And I've been experimenting with the Zoom function, and I'm pretty proud of myself because I think I figured it out. So let's look at this first paragraph here. So with regard to, we've got a proposed ward here named Jeff, and these are all real paragraphs that we've put together, of course, not real names for people. So this says, like I said, yes, he's got developmental delay and cerebral palsy. But let me tell you more. So one of the things that you'll see included here is that Jeff stayed in high school until age 22. That's an indicator that if someone is in high school till age 22, they've been following special education curriculum, have required additional supports. So that is something that's, illustrative of the fact that there could be a need for a guardian. Then we're going to let him know what Jeff's up to now. He's in a vocational day program 5 days a week. He's conversant, but has trouble staying on topic, because remember the standard here to make or communicate significant responsible decisions. So that's what we're trying to prove here. So though able to communicate regarding his medical care, he's not able to weigh and appreciate the consequences when presented with options regarding his medical care. Is he going to pick whichever one's the least painful or the least bothersome, or the second option that the doctor gave, regardless of what it is? Also, is the proposed ward able to be left alone? That's another thing that is demonstrative of the need for a guardian. So he can be left for short periods of time, but not overnight, and not going to be able to live alone. He suffers from anger issues, sees a psychiatrist, has been diagnosed. I find this helpful when you're working with judges, guardian ad litems, clerks of the court. If you can equate functioning to a grade level, I feel like that really can help demonstrate in a way that folks can understand the extent of a limitation. So here we have emotional control equivalent to that of a 3-year-old. And he receives medication. He's under the care of these doctors. And so this is the kind of information that you provide. So, I mean, something here like, due to his CP, he's unable to ambulate. So, that's not anything with cognitive functioning. I mean, I would still include that just because it helps for the evaluator as well. Anything that you want the evaluator to know going in, like you might think that, well, gosh, when Jeff's in a good mood and happy, he can get his act together, and it might be hard to really see the extent of his limitations. So this paragraph as well gives you the opportunity to get information in front of the evaluator that they will then know to kind of follow up on when they meet with the proposed ward. Okay, so let's look at another, scroll down. Okay, scrolling down the page here. I think if I go here, then I can get these next 2 in one. Okay, so here's another one. We got Mike, we got Jordan. So Mike has been diagnosed with moderate intellectual disability, autism, and a seizure disorder. He's able to read single words and short, simple sentences, generally believed to understand more than he's able to express. And additional things. I won't go through the whole thing, but because I think we've already touched on a bunch of the things that I feel like are important to put forward. The other big thing that would be important to include is if your child is nonverbal and not able to communicate with regard to the usage of assistive devices even. That makes it very clear that there's going to be a need for a guardian. The other thing that often gets included in these explanations as well is vulnerability. Sometimes we might have someone who is intelligent and able to do all sorts of things on their own, but they don't understand stranger danger. They think everyone has the best of intentions. And there's a vulnerability there that you would be concerned about them being out in the world, making their own decisions about things. So kind of feel like I've beaten the dead horse here enough. This paragraph is very, very important, but certainly refer back to these examples and just pick and choose what applies to your child, and always keep that standard in mind. What demonstrates that my child cannot make or communicate significant responsible decisions? If there has already been an incident of your child being taken advantage of, maybe friends at school, maybe giving up their lunch money, any of those types of things, examples are great. So perfectly fine to include examples because that fully paints the picture for the court. Okay, so back to the section of the petition where it asked about, are there any rights that need to be retained by the proposed ward? So in order to know what needs to be retained, you need to know what's being taken away. I would say more often than not, I wouldn't say though, yeah, I think it probably is the only. Typically, the only thing that we put in this paragraph has to do with attending a college program. So we're going to look at that in just a minute. But rights, so for most folks, this section of the petition is left blank. When it says what additional rights should be retained, we just put NA and move on. But again, your mileage may vary. So the rights that are taken away, the right to enter into marriage, the right to enter into a contract, and those two are kind of related because really at the end of the day, marriage is just a contract. And people will shudder about having that right taken away because it feels very, very invasive. But the important thing to realize is getting married can affect your benefits. Getting married affects inheritance rights. So there are reasons. Any of these rights can be restored if it comes down on a case-by-case basis. And I've had people come to me and say, hey, we want to get this right to get married restored. Then after we had a conversation of, okay, well, she's going to lose the SSDI benefits on your record and his assets are going to count toward her benefit eligibility, all that sort of thing, we might or might not decide to actually restore it and have a full legal ceremony for marriage. But marriage is a contract, and so that gets taken away. The right to determine where to live, when that right gets taken away from the ward and vested with the guardian. So the guardian is in the person who gets to decide where the ward lives. The right to consent to treatment. So the guardian becomes the person who decides what treatments are going to happen. However, the ward can and should still be permitted to participate in those decisions to the extent possible. And the right to revoke a revocable trust is taken away. That doesn't apply to, I wouldn't think, to most focused families for this audience. Now, here are the rights that are not lost. So the right to refuse treatment. This has to do with involuntary commitment. So being someone's guardian is not enough to involuntarily commit them against their will for treatment. That is a separate proceeding, a 1013, a 1021. That's still done through the probate court, but being guardian alone is not going to be enough to do that. The ward does not lose the right to independent counsel, because what if their guardian is being a jerk and not doing the right thing? They need to be able to go and hire an attorney to rectify that situation. The right to contest the guardianship. They can always say, I don't need this guardian. They can file pleadings with the court. They have that right. The right to vote is not lost under guardianship. This is a very common misconception. It can be included in the rights to be removed, and certain courts will ask about it and say, you know, does your ward have an interest in voting, and do they understand that sort of thing? So it can be removed, but it is not automatically removed. And if you say you don't want it removed, then the ward has that right to maintain the right to vote. The right to make a will. A ward can still make a will. Now they have to understand and pass the same capacity test that everybody who makes a will has to pass, which is to understand what it is they're signing, know what the extent of their assets is, what things they own, and to know who their heirs at law are, like who would inherit if they didn't have a will. But if the ward can understand all of that, just because they're under guardianship does not mean they cannot make a will. And this one relates back. They don't lose the right to participate in decisions that include them to the extent possible. So going back to this particular section of the petition, which I think is paragraph 5, the rights that should be retained for certain college, for just by the ward in general. If your child is going to attend an inclusive college program, if they are going to go, like, in particular, this situation arose and came to our knowledge under the program, the UGA program for destination dogs. We had a client who was under guardianship, and they came back and said, oh my gosh, we can't complete our registration because our child is under guardianship. And UGA says that the child themselves has to be able to agree to certain things. So if your child is going to go to a post-secondary program, you know, the Destination Dogs or Clemson Life or Auburn Eagles, you know, one of those things, then they may need to retain some of these rights. So you can go ahead and put it in to the petition for that part, because then that way you've got those rights. Doesn't mean they have to go to this program. But so the things that the schools want to see them be able to consent to is to adhere to the code of conduct, to select their own course of study with the assistance of administrators, and also to consent to being photographed and also used in publications to publicize the program. So when we have someone that potentially will be attending a college program following graduation from high school, we will include these as rights that need to be retained. And the court takes no issue with it. We have not run into any problems with it. Just important. So in the case where we hadn't done this for the very first time, we did have to go back to the court and get those restored. And again, that was easy enough to get done as well. You know, the courts are thrilled to hear that there are programs out there to participate in, but just save some hassle to do it from the get-go. So paragraph 6, this is the one that says who needs to be notified on behalf of the ward. So, and again, the intent behind this is so that the ward is not being taken advantage of, and that those potentially closest to the ward are aware of the filing of this petition. So the way you determine who to put there is Tier 1, if the proposed ward, so this is not the petitioner, this is not you, this is the proposed ward, your child. If there is a spouse, that person must get notified, and all living children whose addresses are known must get notified. So probably not going to apply for a lot of your you know, kids that you're doing this filing for. So we're probably going to bump down to Tier 2 and say, okay, who do we need to notify? So if there's no one in Tier 1, then you must notify 2 adults in the following order of priority. Lineal descendants, so again, that's kids or grandkids, probably don't have any of those. Parents and siblings of the adult ward, those are only adult siblings, so siblings who are over the age of 18. And the parents, if the parents are our petitioners, they don't count. So this, you know, if we've got, you know, mom and dad as the petitioners, they're off the table in this. They are clearly already know what's going on. So we would say, okay, are there adult siblings? And maybe there's only one adult sibling because the other siblings are still minors. So we put that one adult sibling on there, but we've got to find 2 folks So then we can move down to friends or other family. So once you get beyond adult siblings, it's fine to notify, you know, Aunt Susan or grandma or, the next door neighbor, whoever. There's no priority once you get beyond those parents and siblings. And you'll see on the petition, you list the name and address of those folks. Okay, so that takes us through that last page. We're on to the next page of the petition now. So, on behalf of the proposed ward, has a petition for permanent guardianship, or has that ever been created? Have we been through this process before? And probably your answer there is going to be no. And also, has a petition ever been filed and denied? That's the next subsection down there at E. So our answer there, again, probably going to be no as well. Now the court goes into asking about assets and income. And typically what we do on this is we just leave that first part blank. We say, you know what, not applicable to our situation because we are only asking for guardianship. We're not asking for conservatorship. However, it is going to be on the court's radar that, well, wait a second, is this person getting SSI and is it going to a rep payee? So I would go ahead and put that in there if that is the case. If they're already getting SSI, even if you're going to be applying for SSI, I would put that there and just make a note that yes, there's going to be some SSI, but it's going to be payable to a representative payee. This goes on, asks more and more about not only what their assets are, but as you will see down there at the bottom, it gets into what their expenses are. And so this is all, if you are only doing guardianship, this conservatorship is going to be not necessary. And it's kind of beyond the scope of what we're talking about here today. So for paragraph 11, this is back to the guardian ad litem. If you recall, I talked about, there could be another attorney appointed to take a look at the situation as a whole and say, okay, yeah, I've talked to everybody, judge, and I realize they're making kind of an unusual request under this petition, but I've investigated it and I think all is well, and I think you should approve the petition. The judge, of course, is not bound by what that guardian ad litem says, but there is a lot of weight put on it. So I would say the most common, you're probably going to be an NA here. And if you're not an NA here, you might be getting beyond the scope of a DIY guardianship petition. But for most folks, there aren't any special circumstances going on here. The most common thing that will lead to needing to put a request for powers here is if your child already has assets in their name. Maybe they've got, an account that birthday money and holiday money and everything has gone into over the years. And now it's got $20,000 in it and it's in their name. And we're thinking, oh, shoot, we've heard about these benefit stuff and it's going to potentially mess up eligibility for SSI. What you would put here is to say, hey, we need the ability and permission from this court to take the money out of the child's name and put it into a first party special needs trust or put it into an ABLE account. And you put that request here. That's probably the most common thing that we would ever see here. Also, if there's been a personal injury settlement, an inheritance, something like that, that's what goes here as well for special powers. So again, if you're in that arena, you're probably beyond the realm of a DIY petition. So if you're filing this on your own, it's probably just going to be an NA. These provisions at 12 are relatively new within the past, I don't know, 5 years or so. Was the proposed ward physically present in another state for 6 consecutive months during the preceding year? This, again, probably doesn't apply much to you, but just to give you an idea of why in the heck it's in here. This has to do with granny snatching, which is a term in my elder law world where, a kid goes and picks mom up from Florida, plops her in Georgia, and files for guardianship to get control. So the court added the petition to say, where's this person been for the past 6 months? So you're probably going to say, nope, hasn't been living outside outside of Georgia for the past 6 months. Did the proposed ward live alone is the next thing you want to answer. So it's like, okay, well then who has this proposed ward been living with? And so here you can just put the parents, or if there's an adult sibling that lives in the home, you can add that there too. So then that would be it for this page. Or if they had been, maybe you did just move here from, California. And so by coincidence, yes, you have lived somewhere else in the past 6 months. If you have, then down here at the very bottom of the page is where you're going to put folks who knew you in California, family, and provide the court with that information just so they can check out, make sure you haven't kidnapped your child for the purpose of getting guardianship. This portion, you'll just want to copy word for word. That's why we put it in here. The court says, hey, do we have jurisdiction over this case? Have you filed it in the right place? So you can just put this verbiage right here, basically saying, yep, the ward is domiciled in this county, has been in this county. We didn't bring him here just for the purpose of filing for guardianship. So just copy that part. Additional data, probably not anything else that that you need to provide there. And then here, finally at the bottom, 15, that's where everybody signs. Put your name, your mailing address, your telephone number. Might even throw in an email address because the court likes to communicate. They haven't added that to the forms yet, but the court does very frequently communicate via email. So I would certainly add that there as well, if that's convenient for you. If you would prefer that they call you so you know the email doesn't get buried or whatever, don't add it. But and then as far as the information of an attorney, fine to put NA. You do not have to have an attorney to handle this. So then there are some more signature pages. So this is what's known as the verification. So you would just fill that out with the county. You sign it in front of a notary and print your name, and make sure the notary stamps, and make sure that the notary stamps once for each person. Even if it's the same notary, write in the expiration date of the commission, even if it's listed on the stamp, write it on there. These are just, pro tips as to how to make sure that nothing gets rejected by the court. So this is the thing where basically it's the two petitioners that are saying, yes, we swear everything that we've put in this petition is true. So if you are asking the court to be appointed, you need to express to the court that, yes, I'm willing to serve if I am appointed. So this is where you say, yes, I blank having been appointed as guardian, and I blank having been appointed as conservator. If there's not one, just put NA. And so you sign there and provide your information again. If there are going to be co-guardians, both of you will need to sign one of these and present it to the court. So you can just do a separate one for each person. Then this is the affidavit. You will see this in the standard forms. And but if you're not using the affidavit of the physician, which as I've mentioned multiple times, I recommend against. If you're not using that, then you don't need to submit this page. You can just leave it out. Here we have an acknowledgement of service. So again, you would complete this with the county where you're filing, the name of your proposed ward, and then this is the people that are listed in paragraph 6. They don't have to sign off beforehand, but if they do, then it can potentially speed up the process. And I use the term speed up loosely. Typically takes about 8 to 12 weeks from the time you file to get to the point where you're standing in front of the judge and getting appointed as guardian. So, anything you can do to make the process a little bit smoother for the court is typically appreciated. So if you've got the child away at college and then Aunt Susan who are doing this, you can provide them all of this ahead of time, have them go ahead and sign off on it. And then when we file it with the court says, oh, great, Aunt Susan and Brother Joey already know about this, and so therefore we can just check that box and don't have to have them served by certified mail and wait for the card to come back or wait for the service acknowledgement to come back. So again, I would highly recommend using folks that you can get to go to the notary and make this happen, or facilitate getting that college child to a notary, which, trust me, can be a challenge in dealing with these petitions, but we get it done because it is worth it. So just the last thing here, some courts are going to require additional forms, not just the petition. And so I would check with the court. You might check on their website or even call the clerk and say, I'm filing a petition for guardianship. Do you have any additional forms? Some do, some don't. Almost all of them require a criminal background check. So you're going to have to sign a form that consents to that. You have to provide your social security number because they're going to run it through a criminal database and make sure you don't have criminal history to serve as the guardian. And then there are various things called like a guardian information sheet where they just want to know maybe your name, your address, your employer, and a qualifications questionnaire. Interested persons worksheet is where they might say, okay, I recognize we've got our petitioners and we've got those folks you listed in paragraph 6, but we want to know, are there any other siblings that weren't listed? Are there any caregivers that live with the ward? So that's where they're just looking to see, hey, we want to have in our records, who are the other people that are important in the ward's life. So it's going to be really the criminal background check, some sort of information about the guardian, and then maybe that interested person's worksheet is what I would expect. But do contact your court because, again, if you the less back and forth you can have with the courts and the neater the package that you can deliver to them, the more smoothly everything is going to go. So there are, like I said, here's the website again, where all of the information and forms are available. There are videos you can watch there about how to be a guardian. And then also we've got videos on our website as well that can provide additional information. So I think that gets me through my materials. I've got potentially 5 minutes for questions. I don't want to jump ahead of Jade. I know she would probably jump in and say that, but
No, Heather, thank you so much. I mean, oh my gosh, this information, it's so important. Yes, anyone that has a question for Heather, please unmute or add your question to the chat box.
I came in late. Will there be a recording for this somewhere?
Yes, this will be available on the Focus website by the end of the week.
Thank you. Appreciate it.
We have a short time with Heather. Any important questions that you have about your guardianship?
I just wanted to ask, oops, sorry.
I'm sorry. Do we need to fill the rest of the application, the pages after page 18?
Oh, thank you for asking. Thank you for asking. Yeah, so there you will see in big bold print, like, hey, here's some additional pages and you have to fill these out. You do not have to fill those out. Don't fill those out. The court's not going to use them if you do fill them out. Thank you for asking. So yeah, just get to the point, the ones that I had shown, and then to the page in that standard form where it says complete the rest of these, you don't have to.
Thank you.
Yeah, my question is, when do you start the process? My daughter is about to turn 17.
Yes, so the process can be, you cannot file the petition until your child is 17 and a half. The exception to that is Forsyth County. Forsyth County requires the child to be 18 to file, but any other county you can file at 17 and a half. I would recommend that because it takes, can take about 3 months or so to get it done. If everything gets completed and your child is still not age 18, then the court just holds on to the file, and on your child's 18th birthday, they will issue those letters of guardianship so that there's no gap. So I would say 17 and a half is when you want to get started. And you could potentially get started, with the paperwork and stuff even prior to that, but it's just you can't file it with the court until 17 and a half.
Thanks.
Thank you. One last time for a burning question for Miss Heather. Well, Heather, that just means you gave us so much info.
Okay, I love it.
We are loving it. Thank you so much for giving us your time. As someone just added to the chat box, thank you for the great information. We appreciate you so much. And for anyone that doesn't know, Heather will also be at our upcoming conference in January as well. So please feel free to reach out to her via their website, the phone, and then you can also see her at our upcoming conference.
Well, I will look forward to that. We will have all survived the holidays by then. So I will look forward to seeing you in January.
Yes, absolutely. Thank you so much, everyone. Have a great day.
All right. Have a great day.